The Marcus Allen Ruby v. Samantha Granzo Carranza, not quite sure. Apologize. I don't know if anybody.
She was just checking which.
Go get it.
Call me right now.
And Your Honor, this is Amy Trimble. I'm the GAL on that matter.
Oh. So my judicial assistant tried to reach out to the parties and did not hear back from the parties, but this matter is being set over to September 24 at 1 p.m. I have a conflict in hearing the case. So it will not be this morning.
Can I ask what the conflict is?
I have information in regard to the case that would not make it fair for me to hear the matter. So I will not be able to hear it. So it'll be set over to September 24 at 1 p.m. in front of Judge Basher.
Right. Thank you.
Thank you.
Oh, good.
Please mute your connections until your case is called. Who do I have here present on this matter?
Christine Dow representing Noah Broderius.
Curly Bliss on behalf of Shauna Broderius. My camera started glitching. Can Your Honor hear me okay?
I can.
Okay, very good.
So this matter comes on for presentation of order. I did review the request and objection by Ms. Bliss in regard to two matters. And Ms. Dow, I didn't know if you had any comment on either of those.
No, Your Honor, my only comment is that the visits have been going well. Seasons are turning. There is no reason that the child shouldn't be able, or the children shouldn't be able to at least go to their dad's home for a couple of hours. They don't do that. They wouldn't want to be doing that every time. Ms. Settle has plenty to do so that she wouldn't have to be there. We're asking the court to enter the order as my notes indicate and the recording clerk's note indicate that the court only ordered that the 3-hour visitation on Sunday would continue. Not that any of the other details of the parties' previous one-on-one agreement remain in place.
Ms. Bliss?
Your Honor, my notes did reflect that you had adopted their agreement in full pending a further input from a guardian ad litem. That is why in my objections, I requested that the court simply attach or reference that agreement. As to the weather changing, I understand and I can appreciate that, but I know historically that there was concerns regarding the visits happening at Mr. Broderius' home. The party had previously agreed that it wouldn't occur at his home. I'll defer to the court given Your Honor's ruling as to Ms. Settle being prohibited from those visitations, but I know that that's a primary concern of my client. Secondarily, as contained in my objection, there is the request for specific language as to transportation. I know even since the hearing has occurred, this has continued to be an issue, so I do think that we need some sort of specification as to the transportation arrangements.
So in regard to the agreement, I certainly don't have any problems if they're in agreement with that statement to attach that. So that's approved. And if I didn't address the transportation, I have no problem with the proposed transportation exchange at the child's gymnastics studio, regardless of if it is in session or not. So those two changes will occur to the proposed order.
Your Honor, I would like to just go on record saying that my client does not agree to that arrangement that they had previously. He will abide by it.
Okay. All right. Well, it's what they had agreed to. It'll be adopted and made part of the order.
Thank you, Judge. And with that, I think Ms. Dow and I can probably enter an agreed order ex parte.
Okay. All right.
Yes, Your Honor.
All right. Do we have Ms. Baldwin? We have Ms. Holder. I saw an order, but I saw no objections that had been filed. So I'm assuming that Ms. Holder has no objections per court rule. You're muted.
I'm sorry. You're correct. I do not have any objections. Just one point of clarification. The GAL order goes until January 2024. It should be 2025.
Well, that's fine.
All right.
Just wanted to point that out to make sure that gets corrected.
All right. Do you have where it's at in the order so I can just flip to it?
Hold on one. I'm not sure.
Page 3 of 6, right there at the top. It's just when the final report is due.
Okay, so I will change 24 to 25.
You should also have a companion set of orders for the de facto case. That's 24-5-0006608. Essentially, it's a matching set. Those just include
Ms. Holt-
Mr. Thompson.
Ms. Holder, are you okay if I put approved via Zoom?
Yes, Your Honor.
And I should have asked is, I don't have that case on, so,
It should, I was added last night when I sent the second.
okay.
December 18th.
That's where the 13 came from.
I'm worried about not having cell reception if you go into the parking garage.
All right, I've signed off on the orders and changed that 24 to 25 and put approved via Zoom for Ms. Holder.
Very good.
Thank
And did
you.
Your Honor do that in both cause numbers?
Both, correct.
Very good. Thank you.
So do we have Devin Lockwood?
Yes, can you hear me, Your Honor?
I can. We have Ms. Corey, Guardian ad litem, and we have Ms. Powers. State's involved, but this is just a compliance hearing.
And I'm here representing Miss Coleman.
Okay. All right, so this is a compliance hearing. And if you could let me know where things are at.
Yes, Your Honor. I have been in contact with both parties and intake materials have went out. It was a little slow going due to contact information, but we're all good now. Getting ready to set up initial visits. So everything is on track.
Okay. Ms. Powers, anything you want to add?
No,
Okay. Mr. Lockwood, anything you wanted to add at this point? You muted.
No, thank you, Your Honor.
Okay. All right. So nothing further on that matter. That's it for today.
Thank you.
thank you.
Anyone else here on the Albrecht matter? Do we have Adrian Albrecht? Just double check no one in the waiting room. So I guess at this point, anything that,
And I guess just a quick update, Judge, I'm not surprised he's not here. He did file information at the last hearing in front of Judge Evans a month or so ago, but did not show up for that. I think this is part of his fortunate plan on this. I don't think he intends to participate. I think his goal is just to squat in the home as long as he possibly can. Meanwhile, I can't update the court. My client's now getting information from the lender saying payments have not been made. So we're back in the same spot. He's made it abundantly clear. I don't know how far you went back to the real estate agents who have tried to help him. He's made it abundantly clear to my office. He's made it abundantly clear, I think, to everyone. He has no intentions of leaving, which is somewhat ironic given the circumstances where either we sell the house and they split the money, they maximize the sell of that, which we were hoping was during the summer during peak season, or alternatively, he's going to get evicted through a foreclosure proceeding. So he just doesn't seem to grasp that. He has absolutely no design or intention of following the court order. He's made that abundantly clear. When we were before you in May, he issued the temporary order. He had representation. He had very capable, competent, good legal counsel. Shortly thereafter, there was a withdrawal, and then all these issues have unfortunately surfaced. Client has not had much communication with him. Few communications she has had have basically said, well, I'm going to be homeless if you kick me out of the house. Doesn't seem to grasp the whole logic of you're not paying the mortgage, the bank's going to kick you out, and you're not going to maximize the proceeds from that. I'm not really sure what we do at this point. You saw Judge Evans' order. He made very specific findings. There was some very clear instruction and direction, and today was set over to review compliance, and we have none. So we're in largely the same unfortunate position today that we were last month when Judge Evans heard this. I'm afraid, and I hope I'm wrong, but I don't think I am. I'm afraid the only recourse we're going to have is for to have a civil standby to get him out of the house, or number two, to have him incarcerated for non-compliance. It is unfortunate. But again, there's really little options right now because at this point, he's not answering phone calls. He's not cooperating with agents. And the information we do get from him is basically, I'm not going to pay, we give you that email from a couple months ago. I'm not going to pay the mortgage. So do what you need to do. And then of course, it doesn't help that he doesn't appear at court for these types of hearings. So that's where we're at. My client is admittedly concerned and scared about her credit rating. I'm admittedly frustrated by the non-compliance. I'm asking if we set this over 3 weeks or so, maybe 4, to give him the opportunity to obtain counsel, maybe appoint him. I know there was a GR 33, I think it's 33 or 37, the application that was made. Did have contact with an attorney from Northwest Justice Project several weeks ago, saying that was going to be filed. I don't know that he would qualify for that, but nonetheless, that was the last information I had. But we're going to ask that he go to jail, or alternatively some other recourse to have law enforcement come out and evict him from the home. Not really sure what the right path is on that, but this thing needs to get sold. Commissioner Carmi has been appointed as a special master to sign listing agreements on his behalf. That's great. That's a good first step, but that only goes so far. We need him to actually vacate the home so that we can show the home, get rid of the animals or take the animals with him, do something with those. And to date, you got the information from the agents that says he's basically just thumbed his nose at the court, so I'm not going to cooperate. So that's kind of where we're at. That's the frustration from my end. If we're going to do anything today, I think it's set another hearing and give him specific notice. I will supplement with some kind of a formal motion if the court would like, or a supplemental declaration asking that he be incarcerated for noncompliance.
So the order on contempt from August 12. Did it, I'm just trying to see if it allowed for jail time.
We didn't specifically cite jail time under paragraph 10. And I think that was by design of Judge Evans. We did contemplate that to the best of my recollection. What he did do is kind of leave that open-ended. In paragraph 12 stated the court will review the case on September 17, 2024 at 9 a.m. on the regular family docket to ensure compliance, further orders, and sanctions. So I'm not, again, I know that the court is loath to incarcerate people for, these types of family law issues. I'm just not sure what else we do given the circumstances. I think that's going to be the only way that wakes him up, or alternatively, we have some kind of a civil standby, give him notice and have the police escort him out, which I know is a drain on law enforcement as well. But I think this is one of those cases where we're going to have to probably extreme measures to get him to comply and get this house sold.
So what I would want to do is I would not feel comfortable just adding on jail time to what's here. I think it's going to take a new motion.
Okay.
And service to let him know that's the request. And then I can, because of that, appoint an attorney. At this time, I'm not appointing an attorney for any other reason. So that would be the possibility to kick that into play.
We'll get that out hopefully today and filed very soon.
Okay. All right. So we'll call the review done for today and just go ahead and get that process done, and we'll go from there.
Very well. Thank you, Judge.
Thank you. All right. I have Ms. Bliss. I have Ms. Holder. Anyone else appearing on this matter?
Yes, I'm here, Your Honor. Stephen Mortensen.
Thank you. All right, go ahead, counsel.
Yes, Your Honor. There are two issues here. First, this was a pay or appear docket to make sure that Mr. Mortensen was current in his monthly spousal support. I believe that issue was August and September of this year, just making sure that that was paid. And I do believe we provided evidence to the court and to Ms. Bliss that that indeed has been taken care of and he is current in his spousal support obligations.
And that is my understanding, Judge.
I'm sorry, Bliss.
I said that's my understanding as well. I did receive confirmation from my client and Ms. Holder that those payments have been received.
Okay. All right. Go ahead, Ms. Holder.
The second issue that we're here for today, Your Honor, is a motion to vacate those spousal support payments. I assume Your Honor has had the opportunity to read all the pleadings in this matter, so you're up to date on where we're at and the arguments are being made of, first of all, Ms. Mortensen no longer has a need for spousal support if she ever had a need, and that also Mr. Mortensen does not, nor has he ever had the ability to pay. This case has been going on for approximately 2 years. The temporary family law order was entered in September of 2022. Mr. Mortensen has had difficulty paying that spousal support for the pendency of this litigation, so much so that he's been held in contempt multiple times and has even been held in jail for his lack of payment. He'd had no attorney up until this point. The only attorney that was ever appointed to him was the one that was appointed prior to him being sent to jail for failure to pay. When my firm came on, we did a forensic analysis of his bank account and his financial situation to see where things were going sideways and why he was having difficulty paying every month. And it became abundantly clear that he never had an ability to pay due to his financial circumstances. And it also became clear that Ms. Mortensen does not have a need, and she especially does not have a need right now. She's provided no evidence or documentation to support anything she's asserted in her financial declarations. And she is now claiming that she can't work because she's sick when we haven't seen any kind of documentation of her alleged illness. She hasn't even put a name on it and said what is actually wrong with her, if there is anything wrong. In July of 2023, we became aware through her most recent declaration, her responsive declaration, that in July of 2023, Ms. Mortensen sold the home. And that home was bought with cash proceeds from the original sale of a family home. Ms. Mortensen then bought another home during the course of the marriage, but just prior to filing for divorce. That was taken with, again, community property with the proceeds from the house. That house was completely bought and paid for. It was then put into a hookup at a mobile home park in Woodland. That hookup cost was $1,200, and the utilities she was paying were approximately $490 a month, which put her financial need at $1,700 a month for where she was living. Now she's claiming that she sold the home in violation of a court order, and we've already filed for contempt for that matter. But she sold the home in July of 2023, took that money, hasn't disclosed where that money went, hasn't provided to the court or to my office any information, or to Mr. Mortensen about what happened to the house proceeds after she sold the home a year ago. So that house was valued at $126,000 when she bought it in 2022. So again, where'd that money go? She hasn't disclosed that. On top of that, she's claiming that she was forced to sell the home because she could no longer afford it because my client isn't paying his support payments. Well, now that she has moved out, she is now claiming in her new financial declaration, or her amended one for her expenses, that she is paying $1,400 a month in rent, which that increased it by $200 a month. And she's paying $658 in utilities, which again is more than she was paying. So she's actually paying now $358 more a month than she was when she was living at the home that was paid for. On top of all that, she still hasn't provided any evidence that that is what she is actually paying or actually has a need for that. And while preparing for this case, this is not in the pleadings for the most recent motion, meaning the response and the reply declarations, but it is a part of the court record and it is very interesting. If you go back to the temporary family law order that was put in place in September of 2022, that was done September 27th. Based on the motion to get that temporary family law order, Ms. Mortensen claimed in her financial declaration that was filed in August 19th of 2022, and she signed that declaration on August 17th, 2022. She claimed in section 6 for her available assets that she had zero cash on hand. Mr. Mortensen, for that very hearing, before he hired an attorney, he also filed as a sealed financial submission the bank statements for the joint bank account with Ms. Mortensen's name on it. In that bank account on August 17th, the day she signed that financial declaration stating she had no cash on hand, she had over $19,000 in the bank account that she did not disclose. So what we have here is a situation that has gone on for 2 years where she has been getting support. She has sat on her hands. She has not moved this case forward. He has held my client in contempt multiple times, even sending him to jail when she has not established that there was a need. He has not established now that there is a further need, if ever there was one. My client has put forward his financials stating that I can't afford this. He took out loans to be able to pay for her support. That is not the point of support. He should not be having to take out loans to be able to pay her to live, because there has to be a need and there has to be an ability, and taking out loans indicates that there was no ability to pay. So we would ask the court to vacate the support payments because she clearly doesn't have a need. She has increased her living expenses without providing any documentation that she's done so. She has sold the family home and taken the proceeds. We don't know where those are. She hasn't disclosed close to, we assume, 6 figures. And also, she's never provided the court or my client with any documentation stating what her actual financial situation is through bills, utilities. We don't know that she has paid off or paid down the debt that she assumed. One of the main sticking points for the litigations this far from Ms. Mortenson's perspective has been that she took on the lion's share of the debt. Well, she has yet to disclose if any of that debt has been paid down or paid off, which again would establish that there is still a need for support. So we ask that the court vacate the support payments, and we ask that she pay attorney's fees for having to put my client through all this for 2 years. And we also ask the court to order her to provide evidence and proof of what she did with the house proceeds from the house sale in July of 2023.
Ms. Bliss?
Thank you, Your Honor. And for the record, I do represent Brenda Mortenson. First, I guess I'm confused as to what counsel's request is today. The motion that was provided was a motion to modify spousal support. Her entire argument for purposes of today's hearing seems to be a CR 60 motion to vacate. Nevertheless, the motion before the court is whether or not spousal support remains appropriate. I believe it was Your Honor 2 years ago who entered the initial spousal support order. You found that there was a need. We're asking you to continue to find that there's a need. Before you is a marriage of 26 years. Mr. Mortenson was the sole financial provider throughout the entirety of the marriage, but for the last 3 years prior to separation. He earns upwards of, I believe it was $29 an hour, and he works substantial overtime at $43.50 an hour. He did just receive a raise in May. Looking at my client's income, she works part-time at Walmart. Again, this is a woman who spent the majority of her adult career raising 3 children, while Mr. Mortenson was the sole provider for the family. She works 33 hours a week and earns $17.24 an hour. As you are aware, and like you probably saw within the court record, we are constantly before the court on motions for contempt due to Mr. Mortenson's failure to pay the court-ordered support. We were before the court today to ensure that those payments were made. And what's ironic is on the eve of his motion is the only time he's ever been current and paid timely prior to a court hearing. He has been found in contempt 3 times in the last 2 years, and that's over extensive pay or appear dockets that my client was forced to have him hauled into court to prove that he was paying. More often than not, he wasn't. What I find is ironic, he attempts to mislead this court into believing that he has paid $36,000 in spousal support over the course of the last 2 years. Again, if you look at the amount of times that we've been in court over failures to pay, the amount of times that he has had significant judgments entered against him for his failure to pay, and my client's declaration reporting he's paid $18,500, excuse me, as of the time of her declaration. It's very clear that Mr. Mortenson is continuing to thumb his nose to the court's orders and is now asking the court to either vacate or modify, again, it's unclear, to prevent him from constantly being hauled into court. But I asked the court to look at if there was a need, which Your Honor already found that there was, and that there is still a need. My client provides her budget to the court that shows she's, again, living on modest means and with modest tastes, so to speak. Looking at Mr. Mortenson's financial declaration, and if Your Honor looked in depth into the file, you'll find Judge Evans spent substantial time meticulously going through these financial declarations of Mr. Mortenson, because it's clear he's continuing to frivolously spend and live a life of luxury that my client simply is incapable of living due to his failure to continue to make these payments. If you look at his financial declaration, he indicates he spends $720 a month on eating out. He spends $510 a month on personal expenses. Again, these are luxuries that weren't that the parties didn't live during the marriage. My client provides for you that during the course of their marriage, they lived on one income and they lived modestly. Now he's living essentially the life of luxury, eating out for $720 a month, spending $500 on personal expenses, $500 in gas, and is living with two other adults. So his living expenses are shared. So my client wants the court to uphold the prior ruling if you are considering a vacate, which I don't think is properly before the court. But if you're considering modifying, I ask that you look at those and you see that, if anything, my client's financial position has worsened in the last 2 years, primarily due to Mr. Mortenson's failure to pay those support payments. She provides for the court that when the parties agreed, and Mr. Mortenson was involved in the purchase of the mobile home, that the parties agreed that Mr. Mortenson would pay $1,000 in lieu of maintenance to that space rent. That is the sole reason my client purchased that home. And then, naturally, as it does happen, Mr. Mortenson moves and then reneges on that agreement, says, nope, I'm not paying you anything, which is why we were forced to come to the court back in 2022. My client is of modest means. She, again, spent most of her career as a housewife, taking care of the homestead. She was forced into employment prior to the separation and since separation to be able to sustain her own self and her own living, given Mr. Mortenson's failure to do so. We do believe that there continues to be a need. There's a lot of discussion as to where house sale proceeds went, where that she needs to furnish proof of X, Y, and Z. None of that's been requested of my client. If the court requests it, my client is more than willing to give it. My client does have some medical issues currently. She'd prefer not to broadcast that to open court. She's more than willing to provide it to your honor and to counsel. But again, that's never been requested of my client. My client has simply fought through this process, simply trying to get Mr. Mortenson to comply with the court's prior rulings. She's not just sat on her hands and not pressed this matter forward. And if you look at the record, we have pressed this matter forward numerous times, simply trying to get Mr. Mortenson to comply with the court's order. She has spent thousands of dollars in attorney's fees, simply trying to get him to force compliance, much of which hasn't been repaid, unless it was jail time threatened or contempt threatened. At this point, Your Honor, we're asking that you deny the motion. The request for attorney's fees is frankly laughable. Again, on the eve of this motion, we had another finding of contempt for Mr. Mortenson's failure to pay the court order, an outstanding attorney's fee judgment owed to my office due to that failure, and now essentially requesting either a vacate or a modification so that he doesn't continue to be held in contempt, I think is inappropriate. So frankly, we're asking the court to deny the motion before you today, and if anything, award my client attorney's fees for having to respond to this frivolous motion.
Ms. Holder?
Yes, Your Honor. In regards to the accusations that my client is thumbing his nose at a court order, he's not the one who did not fill out a financial declaration, not disclosing about $20,000 on cash on hand. He's not the one who violated a court order by selling a home a year ago. And I would say my client could be, forgiven for not requesting documents for a home sale when he just became aware of it within the last 3 weeks. We are currently in my office working on getting some discovery to Ms. Bliss's office, but we are also here now asking the court to order her, as a part of this motion, to disclose what happened to that money. We still don't know. As far as my client's wages and living a life of luxury, he makes $29 an hour, $43 for overtime. Overtime is not guaranteed. He pays $750 a month to rent out a room with 2 other people. Again, if you go back to the only financial records that I have for Ms. Mortenson that my client provided from the joint bank account, there's a lot of money going toward DoorDash and $600 at grants. My client's not the one who spent that money. That was Ms. Mortenson, and that was after she filed for divorce. So she's the one who's been living a life of luxury at the detriment of Mr. Mortenson, because he's been stuck paying her spousal support. Also, as far as an agreement that he was going to pay her spousal support, my understanding, and from the record, it says the agreement was $1,000 a month, not $1,500 a month. It seems pretty clear, based on what has been reported to the court and what has not been reported to the court, that Ms. Mortenson is making allegations and she's making assertions as to her finances and her living situation without actually proving to the court that she still has a need. I believe the motion also says a motion to modify or vacate. My client would prefer vacating it, but he would be okay with a modification that is set to what her actual need is, which she still has not established now. Even if there was a need in the past, which Your Honor did sign off on that temporary family law order, she has not proved that there is a continuing need. We are now calling that into question. And we are asking that she provide documents to the court to establish that there is a continuing need. So she can say what she did with the money from the house, and she can provide bank statements or utilities or something establishing that what she put in her amended financial declaration is in fact true and there is a continued need. As far as my client living a life of luxury, spending money on food and getting himself food is not necessarily a life of luxury when he is a man living on his own, and that's what he's paying his money for, is to have food brought to him because he actually does have a diagnosed medical issue of diabetes, and he's been very clear with the court. Part of the other that is in his financial declaration is for his diabetes treatment and management. Again, even if my client was unable to pay previously and he did have an ability, now we're calling into question her need. We're still asserting that he does not.
Let's wrap this up. I'm hearing the same argument.
Yes, Your Honor. We just ask that you vacate the spousal support or set it at a very much lower amount. If Ms. Mortensen can in fact prove that she still has a continuing need.
So here's what I'm going to do. Before the court does anything in regard to this, the court wants to see exactly what happened to the proceeds from the sale of the house. Supposedly there was about $168,322.89 in proceeds that, from what I can tell, are currently unaccounted for by the petitioner. And the court wants to know where are the funds. Meanwhile, the current maintenance remains, but the court will consider the request once it has more information from Ms. Bliss's client, in particular the house sale. And I'd like to know more about where she is financially on her bank accounts. So provide the accountings. I think it was October 8. Is that when the contempt matter is?
Yes, Judge.
Okay, so I'll set it to October 8 to get that accounting done. And then the court will take further look at Ms. Holder's client's request and go from there.
Does the court need any kind of written order in the interim, or we'll just handle it at the 8th?
Yeah, we'll handle it on the 8th.
Thank you, Your Honor.
All right.
Thank you, Judge.
Thank you.
Thank you, Your Honor.
We're here today on two matters. The first one being the motion to modify or motion to vacate that we had previously filed. And then we're also here on the contempt motion. So first I will go over the contempt motion, as I think that one's pretty clear cut. Ms. Mortensen violated the temporary family law order by selling the family home. She never disclosed this until we brought about the motion to vacate the spousal support. She sold the home back in June of 2023. She's had plenty of opportunity to disclose it to the court and to Mr. Mortensen. She also never disclosed what she did with those proceeds until the court ordered her to do so. Her sale of the family home was not in the regular course of business. It wasn't a normal occurrence. Further, it was not done to pay for basic necessities. Nowhere in her responsive declaration does she lay out the necessities that she says that she needed to pay for to sell the home. In fact, she said that she sold it because she just couldn't afford to live there anymore. And according to her new financial declaration, her expenses went up after she sold the home. She said she couldn't afford it. There was a $1,200 lot fee. She then sold the home, and then she ends up living with her daughter, paying $1,400 a month. The house that she sold was bought for approximately $126,000. She sold it for $83,970. That's about a $40,000 loss in about a year's time. Not exactly sure how a home decreases in value by that amount of time. My client was unaware she sold the home, had no input if this was a reasonable price to sell it for. And then on top of that, she used the money. She's been sitting on it for approximately a year. She has about $37,000 in it in her bank account right now from the sale of the home. She, again, did not use it to pay for necessities. She might have used it for some basic living expenses, but she also did things like go to the spa, buy concert tickets, and pay $5,000 toward her son's student loans. Again, that's not a normal course of action, and it is also not a basic necessity. She is in willful and wanton violation of the court's order that was put into place. And she knew she sold the home, so it was willful. She did it out of her own will. And it was wanton because it was the largest asset that this couple had. And she sold it for a loss. So she wasted the money. And there's basically no money left from the family's largest asset. So we would ask for a finding of contempt. When it comes to the motion to modify or to vacate the spousal support, on her declaration as a part of the temporary family law order that originally started this case, and in her motion for spousal support, that the financial declaration she signed was filed on August 19th, 2022. She signed that document on August 17th, 2022. In page 3, section 6 of that financial declaration, assets or cash on hand, she left it completely blank when really she had $19,922.49 in the bank. She did not disclose that to the court. At best, she misled the court, and at worst, she lied to this court when she initiated these proceedings. Then in June of 2023, again, she sold the home, sold it for $83,970. That money has been in her bank account since that time. She sold the home because she can no longer afford it. Then she moves in with her daughter. The living expenses go up. She does not have a need anymore for spousal support as she has all that money in the bank and she has had it and failed to disclose it. Furthermore, August 22nd, 2023, when she held Mr. Mortensen in contempt repeatedly because he failed to pay spousal support, when again, she didn't need it, she had the money. When she went for the contempt hearing and Mr. Mortensen was ordered by this court to do jail time for 2 days for failure to pay spousal support, on that date, she had $71,594 in her checking account when she held him in contempt, had him sent to jail. He's been paying support for over 2 years during temporary orders. She's taken the spousal support payments. She sold the home. She has wasted that money. She has blown through approximately $40,000 of that money, not including the $40,000 that she sold at a loss on the home. And she's sat on her hands, just letting this litigation go forward, not doing anything to finalize it, just wasting this money. She didn't hold him in contempt because she needed the money. She had tens of thousands of dollars in her bank account. She held him in contempt because she wanted to and because she could, and it was cruel, and she used this court to do it. Furthermore, she's now saying that she can't work because she's sick and she had to take family medical leave. Well, when she initiated family medical leave this last time in 2024, she was sitting on $50,000 in her bank account the day she started her leave. She didn't take family medical leave because she's actually sick. She's claiming that she has PTSD from this divorce. She's taking it because she knows she has money in the bank and she doesn't need to work. She's repeatedly held Mr. Mortensen in contempt for failing to pay his spousal support when really he's never had the ability to pay. He's taken on loans to make payments. And furthermore, she certainly does not have a need. She has not had a need for the last year because she has been sitting on a surplus of tens of thousands of dollars in the bank account, wasting the money of the house and the family's only asset. So what we're asking is for a finding of contempt. It's very clear that it was willful and wanton. She knew what she was doing and she did it anyway in violation of a court order. I'm also asking for some rather extraordinary findings, Your Honor. First of all, waste, because she sold the home. It was $126,000 when she bought it. It was $83,000 when she sold it. So she wasted $40,000 by not taking a reasonable price on the home. She doesn't explain why she sold the home at a $40,000 loss, and my client had no knowledge of her sale of the home. Then we're also asking for a finding of perjury because she lied to this court. She omitted information on her initial declaration. She has frequently laid herself out as a victim here when really she's a perpetrator. And she has held my client in contempt numerous times, even when she had tens of thousands of dollars in the bank and no longer needed his support. Again, she did it because she wanted to, and she did it because she could. Furthermore, we're asking that the remaining $37,000 be put in trust with my office until the finalization of these orders. It is very sad that of a $126,000 asset, only $37,000 is left. And a lot of that has gone toward attorney's fees both that Mr. Mortensen has paid Ms. Bliss's office, that Ms. Mortensen has paid for Ms. Bliss's services, and that Mr. Mortensen has paid for my services to dig him out of this mess. I would ask that the $37,000 be removed from her bank account, put in trust immediately until the finalization of these orders. We're asking for $10,000 in attorney's fees for having to dig him out of this mess. I understand that back in 2023, he was held in contempt before all of this became an issue. But since doing a forensic accounting of her bank records and finding out that she's been sitting on tens of thousands of dollars while still holding me in contempt, it was necessary to spend an extraordinary amount of time to, again, fix this terrible wrong. And then we're also asking for a judgment that any spousal support that he paid from July of 2023, as that would have been the first support payment, asking for a judgment in that amount to be taken from her side upon final orders. And that we're also asking for the court to vacate spousal support. She's had spousal support for 2 years. That was plenty of time for this case to be litigated. And in that time, she has squandered their assets and there's pretty much nothing left. And we need to do something about it before there's nothing left. And everything that was left of the home is being spent in attorney's fees.
Thank you, Your Honor. For the record, I do represent Brenda Mortensen in this matter. Looking first at the contempt issue, as counsel indicated, that probably is the easiest issue. The court has no authority to find contempt. Counsel cites a motion for temporary family law order as her basis for my client violating an order. If you review the motion for temporary family law order, there's no mention of this home. There's no mention of paying for this home or maintaining the mortgage or any of that nature. The home was purchased prior to, after the date of separation. It is an argument of my client that is her separate property. I think that's a trial issue, not a motion issue. So looking for contempt, is there a willful and intentional violation to a court order? No, because that court order is silent as to this property. Even if the court were to find that my client did violate that order in some respect, it wasn't willful and intentional because it was in the normal course of business practice. My client provides to you that while she had that home, Mr. Mortensen failed to pay spousal support. The record is very clear that we've been before the court numerous times on motions for contempt due to his failure to pay spousal support. It is because of that my client then had to sell the home. She could not afford to maintain living there. Since then, as you saw in her bank records, she has had to start dipping into those funds again because Mr. Mortensen is not paying spousal support. The argument before you today is to stop spousal support and take away that nest egg that she's living off of. That is not just, and that is inappropriate. And again, think that's an issue for the trial court, not an issue for the motion. Before you is a motion for contempt. I don't believe that the court has the authority to order it. I am asking the court to deny the motion and the requests contained therein. Looking to the request to vacate spousal support, Your Honor heard lengthy argument from both Ms. Holder and I at the last hearing. You requested my client provide medical records and bank documentation. We have done that. If Your Honor had the opportunity to review the bank statements, it is clear that my client is using those funds to live off of. Again, but for Mr. Mortensen failing to provide and failing to abide by the court order for the ordered spousal support, my client wouldn't have to rely on those funds. Now, it's ironic that counsel is arguing that Mr. Mortensen has paid spousal support for the last 2 years. If you look at the filings before you, Mr. Mortensen has only paid spousal support when a motion for contempt was requested or right before this last hearing. So it's very clear he has not. And my client has provided an accounting in her responsive declaration. I believe he's paid 6 payments in the last 2 years. So to blatantly state he's paid 2 years of spousal support is a gross misrepresentation to this court. To be frank, when the court is looking for spousal maintenance and looking for need for stability to pay, obviously we look at 2609090. The amount of money that a person has in their bank account is only one of many factors. Again, to make the representation to the court that my client doesn't need spousal support because she has this money and then simultaneously is asking that this money be removed from her account is a gross injustice. So we are asking the court to deny both motions before you today. Again, most of these issues are issues for the trial court. Looking to the request for perjury, simply stating that my client omitted a line in a financial declaration is not perjury. Asking for waste, again, if you look at the record, and the record is very clear, Mr. Mortensen has failed to pay spousal support, failed to do his duty under this court's order, failed to support my client. She had to use those funds to pay for her necessities. Sure, she has some luxuries, so to speak. She gets her eyelashes done or her hair done once a month, goes to a concert in the last 2 years. This is not a gross waste of the community assets, which again are questionable. Again, this house was purchased after the parties had separated. My client has maintained that house while she resided in there. Excuse me. Again, that's an issue for the trial court, not before the court today. To enter a judgment as to the amount of money my client received in spousal support versus what Mr. Mortensen has paid, again, is a trial issue. There's a lot of discovery that still needs to be completed, a lot of tracing of what funds went where, whether or not it was appropriate to order spousal support. The court ordered it 2 years ago and has not vacated that order before today. Obviously, that's what's before the court today. Numerous judicial officers have found him in contempt. Numerous judicial officers have ordered him to continue to pay spousal support, and he fails to do so. It is only after he is held in contempt the last time that he brings this matter before the court, asking to vacate not only the judgment or the order requiring him to pay spousal support, but is also asking to vacate and enter a judgment for all spousal support that he failed to pay throughout the lifetime of this case. I don't think that's appropriate. Again, I think a lot more information needs to be provided to the court. Testimony has to be provided to the court, and that's an issue for trial.
Ms. Holder?
Yes, Your Honor. He was held in contempt repeatedly because he never had an ability to pay, and that is part of the requisite for having spousal support. It's very clear that she no longer has a need. In fact, she has more money than he does. So if we're looking at the statute, need and ability to pay, neither one of them is there, and neither one of them has, at least for the ability has never been there. We contend that. And then as far as the need hasn't been there since at least the house was sold. If we pay attention to the temporary family law order that was put in place back in 2022, Section 6 says that it doesn't specify the family home. But Section 8 specifically says, do not move, do not transfer, do not sell any property. It doesn't say property that's included in this order. So to go back now and say that this motion for contempt has nothing to do and should not be heard by the court is ridiculous, because it might very well be a trial issue, but Ms. Mortensen was never going to get to trial before she ran out of all the money. And now that we have brought it before the court, I believe that the court absolutely has the authority and the purview based on the provision that says petitioner and respondent must not move, take, hide, damage, borrow against, sell, or try to sell or get rid of any property unless it is a usual business practice or to pay for basic needs. So I think the court order is very clear on this. As far as the contention that we are asking for all the money to be taken from her from the sale of this home and put in trust, they might contend that the home is not subject to any litigation as it is separate property. The fact is they sold the family home and she used that money to pay for this home that she's now claiming is separate property. Even if it was a trial issue, she shouldn't have done that because it would need to be decided at trial if it was separate property. Instead, she found a workaround in order to sell the house, live on the proceeds, hold my client in contempt repeatedly while she was sitting on tens of thousands of dollars. Again, I believe that what we are asking for is appropriate. She is in contempt of the order, and it is absolutely despicable behavior, quite frankly, and it needs to stop. And if we want to make it a trial issue, you can best believe that she'll find a way to spend this additional $30,000.
Objection, Your Honor, that's argumentative and beyond the scope of today's hearing.
I'll sustain the objection.
So yes, Your Honor, we're asking for a finding of contempt.
All right. So I reviewed the files and record, and in part one, this matter needs to get to trial. It's been pending for some time. It doesn't appear to be an overly complicated matter. So why it's still sitting out here almost to 2025 and not going to trial makes no sense. These issues can be dealt with at trial. As far as the idea of contempt, the court is not going to find contempt. The court has some questions in regard to the language, so to have it rise to the idea of willful and wanton disregard for the court order and an intentional action, the court does not find, and so will not be making any idea or rulings as to waste or perjury. Those two particular findings are reserved for trial. So I'm not going to rule on whether or not she caused waste or perjured herself. In regard to the issue on the support, again, this matter has been pending and it was shown and maintenance was ordered. And the court agrees essentially with what's being argued by wife's counsel in the sense that to say, well, I'm not going to pay you the support that I owe, but you do something so that you can take care of your living expenses. Now, agree, there are issues in regard to some of the things that she paid. There's no doubt about it. At the same time, the idea of coming forward, essentially no clean hands there, and to have it try to set it aside. Again, the court is not going to grant that. The issue as to whether the husband is given credit at some point at the time of trial, that's a trial issue, and I'll leave it for that. So it's a mixture of, one, not finding contempt, two, not going to terminate the maintenance at this time, as far as whether the husband can, or excuse me, the wife can claim separate property on what she sold will be left for trial. The waste and perjury left for trial. In regard to, again, the maintenance, the court is not terminating that. However, will be reserving as to whether or not the husband can get credit for what he's paid.
Your Honor, while maintenance has not been vacated, is there any way to modify it based on the fact that she does have that money still in her bank account?
No. And so it's understood. It's from everything I've seen, she sold her home to survive because he's not paying the maintenance that he was ordered to pay. So no. Presentation October 22nd.
That works for me.
Okay.
Thank you, Your Honor.
Thank you, Judge.
All right, we have Ms. Gilmore, we have Mr. Anagnostou. All right, counsel, go ahead.
This matter is on for presentation of the contempt order. My office did present that to the court as well as counsel. Does Your Honor have that in front of you?
I don't seem to have I have a proposed order that was filed on September 10. So an original did not get to me, just so you know that.
I apologize. We did direct the courier to provide a finished copy, but I can present that to the court. I didn't receive any objections from Mr. Anagnostou. It sounds like there was some confusion. He wasn't aware it was on for presentation today. It is a simple order, so if he does have any objections, I'd ask for him to provide that now, or we can circulate this for ex parte entry.
Mr. Anagnostou?
Yeah, Your Honor. This is not on for presentation. It was never set up for presentation. It's a review. It's supposed to be a review of the house sale. Counsel indicated to me today that it was on for presentation. Well, I haven't had an opportunity to review the order. So with regards to the review that this is set up for, I have been working with counsel to get her the information from the escrow company that the house is sold and it's in closing. So with regards to review, my client has complied, and I would ask that the matter regarding presentation be set so I could review the order and raise any objections timely pursuant to local court rules.
Ms. Gilmore, further?
I'm looking at the court's minutes and you specifically set it on for presentation. I timely provided counsel the order, and I think that we're simply just causing delay in getting the entry of judgment. The court specifically ordered him to pay $5,000 in attorney's fees in 14 days. It's conveniently now the 14th day, and he's asking to set over entry of this judgment. It's a very simple order. I don't want to cause any further delay. As it relates to the home sale, I am asking the court to set over the review till I believe the 29th of October. I received communication from the title company today that it's supposed to close on October 24th. My concern is that he sold the house for $325,000. I'm concerned that the judgments will not be covered based on this. So I'm asking the court set over the review and enter the order as presented once provided to court.
Here's what I'm going to do. And unfortunately, on the docket itself, it only has review. It does not have it also on for presentation. The minutes do reflect what Ms. Gilmore has said. Unfortunately, it didn't get on to the docket in that manner. So what I want to do is, because I agree that the presentation is important to get that done, I'm going to just set that on to next Tuesday at 9 a.m., the presentation part of it. what I would ask Mr. Anagnostou, if you can get me the objections that you may have, or let me know if there are any objections, and Ms. Gilmore, get me an original order mailed up to me, then I can go through the objections and agree or disagree and get an order entered. And if that's done prior to Tuesday, great, it'll be entered. But if not, we'll address it next Tuesday. As to the review part of it, sounds like that's being worked on. Mr. Anagnostou, you said a date of October 29th was what date? Somebody's
No, I think council mentioned that. That's the closing date is, my understanding is that the house is scheduled to close and funds transferred on October 24th. I believe that's the date. Council maybe had a different date.
Okay.
Yes, Your Honor. Sorry.
Go ahead.
I agree. The closing is the 24th. So that's what I was asking for, is setting over the review to the 29th, just to ensure that everything has been paid and resolved. I'm concerned about what he sold, the fair market, way below fair market value. So I'm concerned that the judgments can even be covered with that amount. That's the only reason I need a review.
All right. So let's go ahead and set on for the 29th, a review of the sale of the house. And then again, for next Tuesday at 9, we'll go ahead and do the presentation, but Mr. Anagnostou will get me his objections prior to. I'll review it as soon as I can once I get those objections.
Thank you, Your Honor.
All right. Thank you.
Your Honor, Christine Dow representing Eric Larson.
Anyone else appearing on that matter?
I don't see she goes by Ms. Sanderson now. Could she be in the waiting room?
Let me double check, but I don't show anyone in a waiting room.
Okay, well, she was served on August 20th. We have had no response to several emails to her. It may be she decided not to appear.
Yeah, I don't know. So I know what your request is as far as suspending reunification, correct?
Yes, Your Honor.
Okay. So Ms. Turnbull, are you present? Yes.
Yes, Your Honor. I
Okay.
apologize.
Are you driving? Do you need to pull over?
I'm in the passenger with the headphones on.
Oh,
Yes.
okay. All right. Good. All right. So any thoughts in regard to suspending the reunification?
Your Honor, after I filed my report, I believe I was just charged from the case, but I do have serious concerns about the reunification. So, and just following along after what happened with the first counselor that I had recommended, and Ms. Sanchez's behavior with that counselor, I would have recommended it stop at that time.
Okay. All right. So Ms. Dow, I reviewed the files and record, and I'm granting your request at this point. So I don't know if you had anything else you wanted to add at this time.
Nothing except to say for the record that the child concerned here was pretty clear that he just wanted to suspend it. He's not saying he never wants to speak to his mother ever again, but at this time, he would like us to wait until he's ready.
Well, overall, it just doesn't sound like things are going well. This is to be in the best interest of the child. And I understand reunification can be difficult, but it seems that that's gone beyond that. And mentally, it's to me, it's harmful to a child to continue. So that's why I'm granting your request. Hopefully at some time there will be a better time, but it just doesn't seem to be the case at this point. So I'm suspending the reunification.
Thank you, Your Honor. And I believe we delivered a copy of the order for your signature. Do you have it?
Let me just double check. I don't have an order from you. So if you could go ahead and send over an original and just put that the mother did not appear, and then sign for you, and then just put it to my attention.
I can do that, Your Honor. Thank you.
All right. Thank you. All right, this is a motion for order requiring respondent to pay GL fees and approve temporary parenting plan. Ms. Turnbull, my understanding is that you've been paid in full. Is that correct?
That is correct. Yes.
Okay. All right. And you are?
Daniel World.
Okay. All right. So that part is done. So Mr. Trotter, was there something else?
Yes, Your Honor, on the temporary parenting plan, we're asking the court to approve our temporary parenting plan and adopt our proposed parenting plan based on what we believe to be a change in circumstances.
Okay. Mr. Worrell, anything you wanted to say in regard to that?
I wrote it in our declaration, but on her declaration, she stated that I had not completed any hair follicle test or done any proof of treatment or for the drug and alcohol assessment. I have that. My attorney at the time, Chad Zandy, should have, I believe, given that to the court. If not, I have copies of my assessment from Awakenings, drug hair follicle test, and a monthly compliance report from the BBIT. And so all that is in compliance and doing the best to get that taken care of, as finances allow and time. But I believe we're doing everything possible to get everything done is to the court's likings. So I don't believe that changing the parent plan is in Declan's best interest. I think everything was going well with 50-50 and he seems happy. And I just also at some point want to address the joint decision of schooling, if we could. It was ordered to be a joint decision. Lakin had said she had registered prior to the parenting plan being in place, which was incorrect. She had done it May 10th. The order was put into place April 23rd. I'd like that to get addressed to see, because we would like him to be going to the Castle Rock School District. That's where all his brothers go. That's where all the emergency contacts for her and I am. She graduated from there. It's a way better fit, in my opinion, for him to go to the Castle Rock School District. And we've lived in the same household for 4+ years, and Lakin has bounced around a lot, and we want him to have stable living and stay in the same school district, not be bounced around also.
So first off, I didn't see what you have there as far as those documents. They may be in here. Okay. There are a lot of documents. So what I would like you to do is make sure a copy of those get to Mr. Trotter as well as to the guardian ad litem. Okay, so the attorney and the guardian ad litem.
I do believe those should have been emailed. If they haven't received them, I'd be more than happy to dig into that. I believe we tried to email Mr. Trotter. So if he doesn't have them, we would be more than willing to get those.
Okay. Mr. Trotter, did you receive those?
I don't believe I received those. Yep.
Okay. Well, so go ahead and try to resend.
Okay.
And then to the Ms. Turnbull as well. That's the guardian ad litem. Okay.
Does she not have those either?
Ms. Turnbull, did you receive those?
I knew he was filing them. So I found, if he didn't email them to me, I don't recall, but I did find them in Odyssey. I believe he filed them on the 29th.
29th. All right, let me go back and find those.
You're more than willing. You can have these copies if you need them.
Well, I'll tell you here in a minute. Okay, just to be careful, because I'm not seeing documents that should be under a sealed order.
There was a declaration filed.
Okay, all right. I was looking for the wrong thing then. Okay. Anything like that, you should always give to the clerk and have them put it under a seal. Medical records always go under a seal. Okay. So don't attach them to a declaration.
Okay.
Put them in separately. Well, it's showing your records. Anybody can come in and see them. Okay. That's why we put them under seal, so somebody can't just come in and look at those. Okay.
I apologize for
that. All right. No worries. So just make sure that a copy gets to Mr. Trotter. Okay.
You can take care of that here right after we walk.
Yeah. Well, they need to be sent to Mr. Trotter. So however you can get those to him. Okay. Okay. All right. Yeah. So with that, I want to hear from anything else that you wanted to say.
I'm a little disappointed that we're in here already. The 50-50 got set up in June, and in the midst of that, I was coaching 2 baseball teams, and trying to mitigate all this whatnot. And so Declan did miss soccer practice. There's also been ones that weren't called off till last minute, and so them stating that we're not taking his sports and schooling seriously is not accurate. I don't believe so. And they had stated in her declaration that we weren't taking his education seriously. We were under the impression that the daycare was as needed, and it was summertime and seemed more appropriate to keep Declan with his brothers at home with my wife, where they can play and enjoy summer, versus if it was known to us, communicated that he was under obligation to be there all the time, we would have been more than willing to do that, but we were under the impression that it was as needed, and it was sometimes, so it seemed more appropriate to have him home with his brothers.
Okay. Ms. Turnbull, can you tell me your position at this point?
Yes. So I have not completed my investigation, and Mr. World just recently paid. We're working on setting up a time for me to come and do an interview and meet with him. So I feel like my information is somewhat limited for his point of view. Okay. I can tell you that based on my previous investigation, which he did not participate in, and based on what I know in terms of his testing and follow-up, that he did have a substance abuse evaluation last summer that did have treatment recommendations. And as far as I know, he has not followed through with those treatment recommendations. He did have a domestic violence evaluation, and he is following through with the domestic violence treatment. And so he is following through with that. And as far as I'm aware, he is in compliance. I am getting compliance reports from Sam Case, who works with Olivia Lovely. But I am concerned about the substance abuse treatment that hasn't been followed up with. And I haven't spoken with him about that, but as far as I know, he's not in compliance with that. My concern with the parenting plan, as Mr. Trotter has proposed, is that there are no 191 factors. And in my first investigation, there was some pretty significant domestic violence that has occurred between Mr. Worrell and Ms. Airhorn. And I do think that the parenting plan, and as well as substance abuse for both parties. So I'm hesitant to support the parenting plan as it is currently written. And I would like more information. And I'm hesitant to, without more information, I'm hesitant to support a 50-50 plan until I complete my investigation.
Okay. Let me just make a quick request, Mr. Worrell. Are you in substance abuse treatment?
I have explanation. When this first all got set in motion, there was a list of stuff I had to jump through, and I am paying out of pocket for everything. And so, being as how I'm trying to mitigate paying all this stuff and being compliant with courts, I'm also trying not to neglect, my other children and family having a lifestyle. So I'm trying to complete these as a checklist per se. I know that's not, what you guys would like to see, I guess, but I am trying as hard as I can. I promise you, the moment the DVIT treatment did conflict with the class times that I would have been able to, because all the other days I have kids in sports and I am responsible for childcare in the afternoons while my wife works. So I'm trying to get through all this as best I can. And I promise you, the moment I'm getting close to completing the DVIT treatment, I will be jumping right on the other ship of that one. I'm not taking them lightly. It's just a matter of time, money, and taking care of the family. So.
All right, Mr. Trotter.
Yes, I just wanted to add a few things briefly. So what we're here for is just to state that we don't believe that the current parenting plan is in the best interest of the child, because one, it doesn't, I don't think when the current parenting plan was implemented, it may not have contemplated the child's schooling. And so the week on, week off, the child is currently enrolled in Columbia Heights. The child has been in that school district for at least a year, attended preschool there. Many of the child's preschool friends are at the new school. The child, again, is enrolled at Columbia Heights. And so we ask that the school remain the same. Again, the week on, week off doesn't work as well because as the respondent asserted or indicated, getting the minor to practices into school has been a challenge for him. Again, I think that's because of the distance between the parties. And again, I think a midway point meetup for drop off and exchange would be appropriate. And I do think alternating weekends, every other weekend would be more appropriate for the school year at minimum. The child has been acting out since the parenting plan was implemented. Acting out includes, the child waking up at night, asking for its mother, acting out. And so those are other reasons that we think it's not in the best interest of the child. The child is engaged with sports, so basketball and soccer, and that all happens at its current school in Columbia Heights. The child has practice 2 times per week and games on Saturdays. So again, every other weekend would be more appropriate. And for those reasons, we say that the child's school primarily and the child's behavior would be the change in circumstances. So we're asking the court to approve the every other weekend.
Okay. So at this time, the court does not want any changes until the guardian ad litem has an opportunity to look at everything. The court found issues on both sides of the parenting, and the court does not find it favorable to the mother to make a unilateral decision about the schooling, and it's not appropriate for the mother to have decided where the child was going to attend. If the parties could not agree on a matter, then it should have been back before the court and a decision could have been made. That said, I am going to leave the child in the school currently because I want, again, the input from the guardian ad litem before any more changes occur. And so that's what's going to happen for now. The requests are denied. And this matter needs to be investigated, and the court will wait for Ms. Turnbull to be able to get the report done.
Your Honor, if I could just ask for the anything with respect to drop off or pickups.
I'm not changing. Well, let me ask Mr. Worrell. He has a question.
When this was first put in place, Ms. Aaron's residence was in Castle Rock. That's why the Castle Rock Police Station was chosen. We're open to a halfway meeting point if the court wants to arrange something like that. It was not, we're okay with, 50-50 distance. That seems fair.
So what would you call halfway?
I'd say Lexington gas station. That's about halfway unless they have a different idea in mind.
Mr. Trotter, he said the Lexington gas station. What's the brand on that station?
Was that I don't have.
I know which one you mean. Yeah, I think it is Chevron.
Yeah.
Chevron. Yep. And
makes more sense. That's fine. The exchange will occur at the Chevron station in Lexington.
Okay, thank you, Your Honor. And then just one other consideration, please, is parties have had trouble communicating via text. And so I don't know if Mr. Worrell's open to a parenting app while this is all going on, but I think that would be appropriate to consider.
Yeah, any objections to that?
No, I think
yeah, that'll be fine.
Thank you, Your Honor. Thank you,
Andy. All right. Okay. I do want to say in regard to the substance abuse, I get where you're coming from. At the same time, it's really important to step up and do everything that you can. So really talk to a substance abuse provider, see what you can do financially.
Okay. And I had this done on the date. It was last fall and 8/18/23. So is this assessment still going to be good, or do I need to take another one?
I can't make that just off the wall. So
you'll need to take another one.
Yeah.
Okay.
All right.
Okay.
Your Honor, just one last thing. If I can just, I'm sorry, just respectfully, if the order required treatment recommendations for him, and so I just want to, on behalf of my client, just say, since she's complying with all of her treatment, I think he should also be engaged in treatment despite its cost.
I get that. That's essentially what I just asked him, told him. Okay. All right. All right. That takes care of the matter for today. Mr. Trotter, are you going to get an order to make those couple of changes?
Yes, Your Honor.
All right. If you can agree on it, just get it to me with signatures, email it to Mr. Worrell, and get it to me to sign off on.
Thank you, Your Honor.
All right. All right. That's it for today.
Thank you.
Your Honor, I have a case before the guardianship docket. Would it be all right if I step out for just a moment to take that case and come back?
I just have one remaining case.
Oh, okay. We'll do that then.
Counsel,
Okay.
did you receive a copy of the report that was provided by the guardian ad litem?
Yes, Your Honor.
Yes, Your Honor.
Okay. And so basically I'd set this over so I had input from a guardian ad litem before making set rulings, and that's been done. I received the report as well. So
Your Honor,
with
might
that, go ahead.
I'm sorry if to interrupt. I did receive an email from Mr. Golahan after he received my report, and I'd be happy to read it to you, but it gives me some pause, and I am inclined to recommend.
Yeah, read it, please.
Mr. Golahan, stop. It's not a part of the record.
Okay, but it gives me some pause, and I am inclined to recommend that either an anger management or domestic violence evaluation be ordered.
Well, Your Honor, that's not before the court. What's before the court is her report,
but as part of my recommendation, I have new information that I didn't have at the time, and I thought the court should be aware.
And Your Honor, I would just note that I think that that's important for the court to recognize, as that's part of what my client has pointed out, is the unpredictability of Mr. Golahan, and that sounds exactly like what's happened once he read the report.
Well, Your Honor, the report already recommends a substance abuse assessment, a domestic violence assessment, and a psychosexual assessment with parental risk component.
Okay. So here's what I'm going to do, because nobody's had an opportunity to review what Mr. Golahan had sent, and understanding as part of your recommendation, what I want to do is reserve on that additional recommendation at the moment. I think there are several things that have been requested, and set this on 2 weeks from now. That way, if you could get that email to Mr. Anagnostou and Ms. Demeter to take a look, then we can potentially and just do a quick supplement to your report, then probably just put it in place at that time. So with that, either counsel at this point have anything to say in regard to the report?
Well, only I was hoping that we could increase the visitation. That was the recommendation to my client. We'd like to especially increase the Saturday visit. I think they recommended, well, we'd like a longer visit so that my client could, the supervisor is his mother, and she'll sign the guardian recommended or requested that she sign the supervision oath, and we'll do that. Not a problem. Just get us the oath and she'll sign that. And if we could have a longer visit so that they could go to her home in Oregon and spend the day there and then return the child.
Your Honor, my client is against the transportation of the child to Oregon. She has raised her concerns as to Mr. Golahan's mother. She understands I apologize, Your Honor, I have a little bit of a cold right now. She does understand that the GAL has recommended that his mother can remain as a supervisor, but she does object to this new request that the child be allowed to go to Oregon. She also would point out if there's anything we could do about the midweek visit on the times. They are not getting home until about 8:15, and it has made the bedtime routine fairly exhausting for the child. So if those could happen closer to her home, her mother is the supervisor on those midweek visits.
Ms. Turnbull, anything else?
Well, I'm hesitant to recommend expanding the visits after the emails. I just have some more concerns.
All right. So here's what I'm going to do at this time. I'm concerned with the additional information that may have been that's been received by the guardian ad litem, and with that, I'm not making any changes at this time. I'm going to set this over 2 weeks, let Ms. Turnbull supplement her recommendation, her report. And that way, Mr. Agnosto and Ms. Demeter have an opportunity to review. Let me ask this, Ms. Turnbull, do you think it's something I should set on for next week rather than 2 weeks?
Your Honor, I'm in mediation next Tuesday. I'm not available.
And I have a week of trial. I'm not sure what date that's going to be. So 2 weeks I already have things on docket in 2 weeks, so that would be preferred.
Okay. So I apologize, Ms. Turnbull, are you suggesting at this time to suspend?
No,
Okay.
but I would, no.
Okay. All right. Let's
I
go
just have
ahead.
concerns. Yeah.
I'm not going to make any changes as far as the visitation. Let's just set this over 2 weeks. I apologize to have kept everyone. But I'd rather have a complete to make it very clear as to what needs to happen, but I'm not going to make any changes at this time. And then on October 29, excuse me, not October 29. That would be September 24. No, I'm still off.
October 1st.
Let's try that.
Yeah, October 1st.
I'm ready for fall, apparently. So anyhow, October 1, we'll go ahead and take a look at this report as well as the supplemental report.
And Your Honor, I do have 2 clarifying questions, if I may.
Go ahead.
The visitation that was ordered, it was my understanding that those, and perhaps I misunderstood the court. However, the visits, they go to the Vancouver Mall. Was it the court's intention that they were able to leave that location as well? And that was just a meeting point. Their visits had previously always been at the mall. Last time my client noticed that they left the location. And so I would like clarification on that. And then are you also extending the restraints that have been in place?
So in regard to the restraints, I don't believe we've ever received an order extending.
That was submitted the
find
same
it.
time as the GAL order. Mr. Agnosto and I signed off on that.
I don't know if it got to the court is the problem. Yeah, there isn't any, so you need to immediately get that restraining order here. I will extend it until the next hearing. All right, in regard to the Vancouver Mall,
Yeah, can I respond just briefly, Your Honor?
I'm looking at the minutes, just a second. I did intentionally make meeting place will continue to be Vancouver Mall. But that I'm not sure if the intent was that it just had to be at the Vancouver Mall. Go ahead, Mr. Anagnostou.
Well, I would ask that it not be. There's other kid places that my client would like to take Parker to. He'd be totally supervised with his mother. But there's kid zones and stuff that aren't necessarily at the mall. The mall is kind of not really kid friendly. It's just shops and stuff. And so he would like, and there's parks and stuff that, at least when the weather was nice, that he would like to take Parker to.
Ms. Demeter?
And we would just like to make sure we know where the visitation is occurring. Obviously, the court's well aware of my client's concerns. She's going to continue to facilitate visitation, but having just seen the daughter being put in a car and taken to an unknown location is upsetting.
Well, that happens in every visitation.
Okay. Ms. Turnbull, any thoughts?
I think as long as grandma signs a supervisor's oath and commits to being at the visitation, that would be okay.
Okay. All right, so let me ask this, Ms. Demeter, are you okay if the father texts your client if they're going to another location?
Your Honor, maybe can my client respond to that? I apologize, I'm not with her right this second, so I would like her to be able to answer that question.
And I don't recall, are they using Our Family Wizard?
No. Ms. Fillion, can you hear us?
Yes, I can.
Would you be okay with Mr. Golahad texting you the location of where they are going?
Is it okay if his mom texts me? I'd
Yeah,
rather not.
right before you said that, I thought that. So
Yeah.
the mother will go ahead and text the other mother, the mother in this case, the location of where they are going to be. And so they're not left to just be at the Vancouver Mall. And that is conditioned on the grandmother signing off on the oath.
And is there any restriction to whether those visits will remain in Washington or if they're allowed to go anywhere?
In Vancouver, they're not to leave Vancouver.
Thank you.
And then if I could ask if Ms. Turnbull has a particular oath that she would prefer. Other than that, I was just pulling offline.
I can send one to you, but it won't be today.
Okay. Thank you.
Mm-hmm.
All right. Anything else for today?
I don't believe so, Your Honor.
All right. That concludes the matter for today.
Thank you.
Thank you.
So this is on for, first off, Ms. Demeter, I still do not have a restraining order. So.
Your Honor, we received back a signed copy.
Okay.
After the last hearing, we submitted it and received it back with your signature.
The dates were wrong on it, right? Yeah, the dates were incorrect. Let me pull it up real quick. The order that was from September 19 extended the matter to August 20th at 9 a.m. So the date was incorrect. It covered a time frame from a prior one, but it didn't cover the current one time frame.
Okay. I apologize. The one we got back on somehow. Okay. I see that, Your Honor, that you signed on May 19th. Well, okay.
Okay. All right. So with that, this is on for purposes of the interim review. And the report I see was filed September 23, 24. And with that, I'm going to turn this over to Ms. Turnbull.
Your Honor, I have met with all the parties. I had originally made a recommendation that Mr. Golahan's supervised visitation be expanded a few hours a week with his mother. He subsequently sent an email, which I have forwarded to the court in another interim review, which I believe everybody received. And my concern is Mr. Golahan's emotional liability and instability, his reactivity, and Parker's witnessing of that. I don't think, as long as Mr. Golahan is sober, that he would intentionally physically hurt her. But I do think I am concerned about his emotional state around her and what she may be exposed to there. I understand this information came into me late yesterday that he walked out of a supervised visitation last week after about 10 or 15 minutes when he became angry and left the visitation, and mom had to come pick up Parker early. So, you know, my conservative side of wanting to protect Parker from that is wanting to maybe limit that visitation so that she doesn't have to, she's not exposed to that until he gets some treatment. I understand, you know, this is going to be a decision that you need to make, and what sort of environment you want to put Parker in, and what kind of environment you're comfortable with her being in. But I do have concerns about his emotional state right now. And so.
Ms. Demeter?
Thank you, Your Honor. Yes, we share the same concerns as the guardian ad litem. Those have been the concerns that we have put forth throughout this entire case. It is concerning to see that it appears Mr. Golahan is sort of devolving from where we even started as he becomes more frustrated with this process. Additionally, we're concerned now that he doesn't have counsel. There's nobody to rein him in. And as Ms. Turnbull's report pointed out, his mother, who this court has allowed against our objections to be a supervisor, doesn't see what her son is doing. Ms. Turnbull's report highlights that she doesn't see these issues, and she's one of the supervisors. And so the question is really, what is Parker dealing with here, and how much visitation should she be exposed to? Ms. Turnbull was also provided some messages with the school where they raised the concern that she's having issues at school after visits with her dad. I see Ms. Turnbull nodding her head. So we would ask there's no expansion, that the court determines whether or not it's appropriate to have some evaluations for Mr. Gullion, and that we just don't expand. And in fact, we would prefer that the visits were limited and that they're only supervised by Miss Fillion's mother, grandmother, as they had been originally. But we understand the court is going to make whatever decision the court is going to make.
Mr. Gulahan? Mr. Gulahan, you'll need to unmute.
Yeah, sorry about that. I was having trouble. Yeah, so
Your
with the
camera
mall.
on. Mr. Gulahan,
Yeah,
turn your
okay.
camera on.
Yeah, hold on a second. Why is it doing this? Okay, yeah, so with the mall visit, I left because Parker was upset. She's tired of going to the mall. And, I gave her a hug and said, I'm gonna leave because you're upset, and she's just tired of being at the mall. So I wasn't angry. I just didn't want to make my daughter be somewhere she didn't want to be. She was tired of it. She didn't want to go to any of the stores. I didn't get angry. We sat and I tried to talk to her. Her mom told her she couldn't eat at all. And so we couldn't eat. It's 5 o'clock. That's a little frustrating for both of us. She wanted ice cream. And I told her no, and she got upset. And that's how that went. As far as the meetings with me and my mom, we've been going to the park, kids club. The last meeting went fine. Parker was really happy the last couple times. We went to the Saturday market. We walked around, did a bunch of stuff, played at the park. It went fine. And then, so I don't know where those statements are coming from. She's having troubles. She's probably having troubles from this whole thing. She was angry that I couldn't leave the mall Thursday. She's asking me to go to kids club, and I said, Parker, we can't leave. I'm sorry. And so she was frustrated that I couldn't leave. And as a 6-year-old, she can't really understand that. She's telling me, yeah, you can leave, Dad. And I'm like, I can't, but Saturday we can. So that's why we went to the kids club Saturday. And so as far as the evaluations, I think it's in my best interest to wait till my trial's coming up. I would appreciate it if I get my trial done and then come back to it, because I'm assuming all this is going to cost a lot of money. I'm not rich, so I'm working as much as I can. I'm missing work because of all this stuff. And then, so that's where I'm at right now. And as far as, with the visits, I would like to see my daughters, at least supervised visits. If anything, I think I need to see her and she needs to see me. And that's kind of where I sit right now. Yeah.
Anything further from anyone?
Well, I will support what Ms. DeMeter said. I was forwarded some emails from the school counselor where Parker reported to the school counselor that she told Dad she didn't want to hold his hand, and Dad became upset, and this was upsetting to Parker.
No, that's not why she was.
Mr. Gulahan, stop.
And Your Honor, I would just say that I understand none of this is in the record, but Grandma completely disagrees with Mr. Gulahan's version of the events, and there was no restriction on them getting food.
So I did review the guardian ad litem's report. This has been set over to get the input from guardian ad litem in regard to what we needed to do. And I appreciate the report. And with that, I am going to follow the recommendations of Ms. Turnbull And so that needs to be reduced to going through them. The supervised visitations will continue. The guardian ad litem has indicated that both grandmothers and any future supervisors sign and file the supervisor's oath, so that is appropriate. And when is your trial, Mr. Golahan?
It's November 19th.
Okay.
Far as I know, so.
So I am going to go ahead and order the hair and nail 5-panel test, ETG or SoberLink. If it, I'll leave it to you to talk to your criminal attorney in regard to that, whether you do it now or not. But if it does, then the weekends could be increased to 6 hours. And so in regard to a collateral substance abuse assessment, a collateral domestic violence assessment, a collateral psychosexual assessment with the parental risk component, the court will go ahead and order those. Understanding, again, you've got a pending criminal matter, and so I'm not necessarily going to, I'm not going to change anything at this point until I see what those evaluations end up being. But I understand if you don't want to do them right now because of the pending criminal matter.
Okay, yeah, I'd like to, if I can, object to that right now. Like I said, I'm innocent. I'm going to prove my innocence, and I haven't done anything to deserve that. And also, it's in my best interest with my criminal case that I don't do another psychosexual evaluation. It's confidential, and with the guardian ad litem cooperating with the.
That's what
you want. Okay, well, I just want to tell you what I'm.
Okay, Mr. Golahan. You're not helping yourself by talking over me.
I didn't mean to, sorry. Apologize.
So those are ordered, but again, understanding they can be delayed until after Mr. Golahan resolves his criminal matter, so we don't put him in a bad spot as it relates to that charge. So Ms. Demeter, can you prepare an order that, bottom line, reflects the recommendations of the guardian ad litem?
Yes. Can I ask 2 clarifying questions, Your Honor?
Sure.
So I do understand that her report had said expanded. What I heard her say today is that she was no longer recommending that. Which recommendation are we going with?
So it's from the report that was from file 923.
Okay. But those expansion is not until after the evals.
Correct.
Okay. Just wanted to make sure I understood that. And then my question on the restraining order, are we setting a review after his trial date and we would extend the restraints?
So why don't you go ahead and, Mr. Golahan, I apologize. You said November
19th.
19th?
Okay.
As
So
far as I'm concerned, yeah, or as I know.
let's go ahead and set a review to November 26th. Is the week of the 19th your trial, you say?
The 19th, that's what they told me.
Okay.
Yeah, November 19th. So
I apologize, but I do have a trial on November 26th that starts at 9.
Okay, let's go to December 3, because I want to make sure that I don't want to set it too close and then find out the trial hasn't occurred.
Exactly. And if trial has not occurred, should we enter an agreed continuance or should we come back?
If you can do an agreed continuance, that's fine. But otherwise, just let's go ahead and look at it on December 3.
Certainly. Mr. Golahan, do you have an email that I may get?
Yeah, it's my first and last name.
Thank you. I will be sending you documents to review for signature.
Okay.
Okay. All right. So that's it for today.
Thank you, Your Honor.
Thank you, Your Honor.
Do you want to do, well, hold on. Ms. Demeter, do you want to do a presentation of that order?
I think that would be a good idea, Your Honor.
Okay, let's go ahead and try to get that in place as soon as possible. So I'll just set it over 1 week. So Mr. Golahan, your next court date is going to be October 8 at 9. So Ms. Demeter is going to prepare an order. She'll send it to you. If you agree it reflects what I ruled, then you can sign off on it. If you don't, then we'll go forward on October 8 at 9. And
Okay.
then we have that other date of December 3, which is the review date of the restraining order.
Okay.
Okay?
Okay. Thank you.
All right. Thank you.
Thank you, Your Honor.